Welcome to the Ninth Amendment Party, South Carolina chapter. All information is verifiable at United States Code, Code of Federal Regulations, Bouvier's dictionaries, Black Law dictionaries, the Uniform Commercial Codes, as well as congressional records. We the people, constitutional principles, securing your private standing. Constitutional principles securing your private standing. A. Contracts Clause, Article 1, Section 10. No state shall pass any law impairing the obligation of contracts. Trusts, settlements, and family conveyances fall under this protection. States cannot forcibly convert your estate into a public probate estate without impairing the underlying private contract of inheritance. B. Due process, Fifth and 14th Amendments. No person shall be deprived of life, liberty, or property without due process of law. Forcing you into a statutory citizenship or probate administration would deprive you of property and liberty without due process, unless you consent. Equity steps in where statutes presume too much. C. Freedom of allegiance, declaration, principle. The Constitution does not compel political allegiance or commercial citizenship. Allegiance is a matter of voluntary association. By disclaiming your commercial citizenship, i.e., John Doe, in all capital letters, political allegiance or statutory identity, you stand in the position of what older jurisprudence called a private American national, owing natural allegiance only, not commercial submission. Rights by inheritance and retention, not license. Natural rights reserved in the Constitution. The Ninth Amendment is central here. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. U.S. Constitution, Amendment 9. This establishes that rights are retained, not conferred. As Justice Joseph Story observed in the commentaries on the Constitution, the Ninth Amendment was added to prevent the inference that all rights which are not enumerated are surrendered. In other words, because that's not written doesn't mean that you have surrendered any particular right. It preserves inherent claims such as inheritance, property, and the right to direct one's estate outside of statutory privilege. Equity as equality, balancing both sides. Equity, by definition, is the jurisdictions of conscience and equality. It ensures justice both for the heir and for the fiduciaries. The heir is protected from unjust presumptions, forced probates, and loss of beneficial rights. Fiduciaries are protected from false claims or bad faith actions. Equity requires clean hands. As Story wrote, equity looks to be the substance and not to the mere form. It will not permit technicalities to defeat the end of justice. Commentaries on Equity Jurisprudence, Section 64. Thus, your living status as heir and beneficiary overrides appearance of form, as capitalized names, registrations, etc., because equity enforces what ought to be done in conscience. Standing independent of license or franchise. A license is a permission from the state. A privilege is a benefit granted by the government. By expressly disclaiming both, you affirm that your status is not derived from civil statutes, but arises from the law of nature and equity. This aligns with Chief Justice Marshall's reasoning in Dartmouth College versus Woodward, 17 U.S. 518, 1819. A law that alters the legal relation between parties to a contract impairs the obligation of that contract, no less than if it releases one of them from the performance of his undertaking. If private inheritance or trust rights exist, they cannot be displaced by statutory license or political allegiance. Example, the right to travel. The state grants your driver's license as a privilege, when in reality, it is not a privilege. It is an unalienable right to move freely. Equity and private trust principles. A. Equity protects the beneficial owner. Equity distinguishes legal title from the beneficial interest, as Perry explains. The title to a trust estate must always remain distinct from the beneficial interest, and the two cannot merge without the destruction of the trust. Perry on Trust, Section 267. Thus, even if the state or a corporation holds the legal shell of an estate, e.g., through registration or statutory presumption, equity preserves the beneficial substance for the living heir. B. Reinstatement of trust. The reinstatement first of trust, Section 17, confirms the legal title may be held without beneficial interest, where the use is preserved by equity in another. This reflects your exact position. The legal estate may appear in a registered statutory or commercial form, but equity reserves the use for you, the living heir. Conclusion. The Declaration rests on three foundations: inherent and retained right, secured by the Ninth Amendment, not dependent on statute. Equitable doctrine of trust, recognizing you as the beneficial owner, with fiduciaries bound to perform once notice is given. Constitutional shields, Article 1, Section 10, contracts, 5th and 14th Amendments of due process, and equities maxims, all preserving private standing against public presumption. By affirming your estate under private administration, you stand in the role of heir and beneficiary, with fiduciaries acting only under equitable delegation, never as superior claimants. C. Executor by equitable delegation. By declaring your estate under private administration, you invoke equity, allowance for executor de son tort, executor of one's own right outside probate, a principle recognized in Godefroy, which means a personal name or a surname, on the law of trust. Equity permits heirs and beneficiaries to appoint fiduciaries for administration, so long as the estate is not abandoned. This preserves private jurisdiction over the trust corpus and prevents unnecessary intrusion by statutory probate. In other words, you are protecting all that you desire to leave as an inheritance for your family, friends, or other areas. Equity conscience, substance over form. Pomeroy's Equity Jurisprudence, Section 59. Equity regards the substance and not the form. It penetrates beyond legal fictions to reach the actual rights and relationships of the parties. This is decisive. Equity ignores whether the name is written in all caps, styled as a descendant, or treated as a corporate construct. What matters is the substance of the living man who holds beneficial interest. Ninth Amendment, retained rights. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. U.S. Constitution, Amendment 9. The right to exist as a living, the right of inheritance, and the right of equitable use of property are among those retained rights. They cannot be displaced by statutory definitions of person, descendant, or estate. Obligation of contracts. If private trust or a family estates exist, the state cannot collapse them into statutory estates. Descendant fiction, without impairing the contract or covenant. This shields you from involuntary substitution into a role as surety or the debtor under the artificial estate. Constitutional principles protecting living status. Due process, 5th and 14th Amendments. No person shall be deprived of life, liberty, or property without due process of law. United States Constitution Amendment 5 and 14. This clause protects the living man against administrative presumptions. Today, all courts operate under the administrative rules, as well as all cities, counties, and states. If you are presumed to be a descendant of an estate, e.g., through prohibition fiction or the capitalized name, your life and property are being administered without due process, unless you consent. Trust law, the split between legal and beneficial title. Perry on Trust, Section 67. Where one person holds legal title to property for the benefit of another, equity recognizes the beneficiary as the true owner. The state, through registration or record, may hold or assert legal title to the construct, all capital name John Henry Doe, but equity recognizes you, the living heir, as the true beneficial owner. Reinstatement, Second of Trust, Section 2. A trust is a fiduciary relationship with respect to property, subjecting the person by whom the title is held to equitable duties to deal with it for the benefit of another. Reinstatement, Second of Trust, Section 17. A person may hold legal title without beneficial interest and vice versa. Together, these confirm that the legal fiction can hold and bear title, while you, as a beneficiary, hold the substance of ownership. Conclusion. Constitutional law protects you, your retained rights, your due process, and contracts from being impaired by presumptions of death or fictitious identity. Equity jurisprudence, Pomeroy, Section 59, ensures that substance, your living status, overrides the form. The capitalized name or probate fiction, trust law, Perry, subsection 67, reinstatement, Section 2, Section 17, separates legal and equitable title, affirming you as the true owner in equity. Therefore, your declaration is not merely stylistic, it is a jurisdictional rebuttal. You are not the descendant, not a corporate fiction, and not a statutory debtor. You are the living heir, a beneficiary, standing in equity in the forum of conscience where rights are preserved beyond form. Equity as equality. Justice on both sides. Equity requires balance. It protects the living heir against loss of standing through fiction. It also protects fiduciaries and the state by requiring you to come forward with clean hands, clearly asserting your rightful position. This satisfies the maximum. Equity will not suffer a wrong without a remedy. If statutory presumption wrongfully treats you as a descendant, your remedy is to declare your living standing in equity, which courts of conscience must honor. Why this defeats descendant presumption? The constructive estate, styled in the all caps, e.g., John Henry Joe, is treated as a statutory law as though it was a descendant estate, an entity administered in probate. But you have not died. You are the living man, and equity presumes against fraud. You do not act as a surety or the debtor for that entity. You are the beneficiary of any rights or property associated with it. Equity separates legal fiction from equitable reality. Substance prevails. Thus, your declaration rebuts the presumption that you are the estate or that you act as an administrator. Instead, you place yourself where equity recognizes you as heir and beneficial owner. Constitutional overlay, the real facts. Contracts Clause, Article 1, Section 10. Courts have consistently protected private settlements and trust. Dartmouth. Due process, 5th and 14th Amendments. Heirs cannot be divested of beneficial rights without lawful notice and process. Wilkins versus Ellett. Full faith and credit. Article 4, Section 1. Declarations of life, domicile, and trust standing must be recognized across all state lines. This is a jurisdictional keystone declaration. It anchors your standing not in the statutory identity, but in equity, trust, jurisprudence, and constitutional protections. To make it airtight, we must explain each component with a doctrinal precision, weave in explicit citations from recognized authorities, and show why it is so imperative for protecting the heir's beneficial interest. Standing as a lawful living heir and the SSDQV Trust. Your declaration begins by affirming yourself as the living heir, not a descendant, or fiction, or statutory estate. The SSDQV, the living person whose life anchors the estate or trust. Equitable life tenant, the one who enjoys the use and benefit of the estate for life. Reservation of rights, 9th Amendment. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. The U.S. Constitution, Amendment 9. This amendment secures your ability to reserve rights not written down, but inherently retained, such as all your unalienable rights given to you by God. The right to claim inheritance, to control one's private trust estate, and to refuse forced joiner are all within this scope. In other words, the state can't force you to a contract. State-level jurisprudence. New York versus Johnson via Fleet. 14 Johns, 472, New York, 1817. The court recognized that where property is conveyed for the life of another is measured by the SSDQV's life. This is the direct American recognition of the term. Massachusetts Clap and Wilder, 176 Mass. 332, 1900. The court stated that equity treats the beneficiary as the true owner of the trust property, despite legal title being elsewhere. Pennsylvania, Hill versus Hill, 79 PA 188, 1875. The court held that the existence of the SSDQV determined whether the life estate continued, Until death was proven, possession remained with the beneficiary. This mirrors the protection of the 1666 Act. Distinction between legal and beneficial title. The Declaration rejects such status as legal title holder or corporate person. This is vital because trust law separates legal and equitable estates. Reinstatement Second of Trust, Section 17. The legal title may be held without beneficial interest, and the beneficial interest may exist without legal title. Perry on Trust, Section 67. Where one person holds legal title to property for the benefit of another, equity recognizes the beneficiary as the true owner. Specific conveyance. By disavowing legal title, you avoid being mistaken as a statutory trustee or a fiduciary debtor while affirming your true beneficial ownership. Let's trace how American courts carried the Cestui Que Vie principle into inheritance, trust, and equity jurisprudence after the Revolution. Transition from English common law. After independence, the states adopted the common law of England, so far as it was consistent with the Republican government. This included trust law and the doctrines of the Cestui Que Vie. Kent's Commentaries, Volume 4, page 305, written in 1826, states, "Equity considers the Cestui Que Trust as the real owner of the estate. The trustee is but the nominal owner with certain fiduciary duties annexed to the title." This became the American baseline. The living beneficiary, the Cestui Que Vie or the Cestui Que Trust, is treated as the real owner. Constitutional anchor. The U.S. Supreme Court has long recognized that jurisdiction cannot be presumed without consent. In Insurance Court versus Ireland v. Campagny des Baixta 456 U.S. 694, 1982, the court affirmed that personal jurisdiction rests upon consent or minimum contacts otherwise. Enforcement violates due process. Thus, your explicit non-consent is a due process defense. Without consent, you cannot be compelled into a forum outside your chosen jurisdiction. Early U.S. case law, Fletcher v. Peck, 10 U.S. 87, 1810. Chief Justice Marshall noted that equity protects bona fide purchasers and beneficiaries beyond mere statutory title. While not a Cestui Que Vie case by name, it demonstrates how American courts observed equity, doctrine, substance of ownership, and technical form. Number 2, Dartmouth College versus Woodward, 17 U.S. 518, 1819. The Supreme Court held that the private charters, including trusts, are contracts protected under Article 1, subsection 10. The implication: a trust established for the living beneficiaries, the Cestui Que Vie, cannot be impaired or absorbed by state action. 3. Wilkins v. Ellett, 76 U.S. 740, 1869. The court affirmed that heirs and beneficiaries hold equitable rights in estates, and creditors cannot override those rights without due process. This resonates with the principle that a living Cestui Que Vie cannot be treated as if it is dead or abandoned. Statutory absorption, pulling the trust estate into probate, taxation, or commercial jurisdiction. Dartmouth College versus Woodward, 17 U.S. 518, 1819. A grant is a contract. and a contract cannot be impaired by subsequent legislation. Trusts and settlements are contracts. The state cannot absorb them without violating Article 1, Section 10, the Contract Clause. Specific conveyance, you are fortifying the separation between private equity jurisdiction and public statutory jurisdiction, making it legally impossible without fraud to presume you into the latter. In other words, they cannot force you to become a public statutory man or woman under their commercial jurisdiction. Equity conscious. You rebut wrong presumptions to prevent waiver of rights, consistent with equitable maxims. This ensures that your estates, rights, and persons are not drawn into public statutory or corporate jurisdiction without your explicit consent, while affirming your rightful status as heir and beneficiary in equity's original jurisdiction. Example, I, John Henry of the family Doe, a private American national by divine inheritance, bloodline descent, and original estate right, do hereby declare and affirm and establish that I am the lawful living heir, the natural born Seste QV, and the exclusive equitable life tenant of the generational trust, holding vested beneficial interests therein by right of the private succession and original title in equity. This declaration arises from my standing in equity as the Seste Q Trust, not a legal title holder or corporate person, and is made pursuant to the laws of conscience, the principles of nature's justice, and the immoral customs of trust jurisprudence, under which beneficial interest is distinctly protected from unlawful merger, mischaracterization, or statutory absorption. Jurisdictional non-consent. Consent creates obligation. Statutory law often assumes jurisdiction through implied consent, as registration licenses, silence in the face of presumption. By expressly withholding consent, you deny the basis upon which statutory systems attach obligations to you. This is consistent with the equitable maxim. He who does not repel a wrong when he can induces it. Equity requires you to speak up and rebut wrongful presumptions, or you may be deemed to have consented. Jurisdictional non-consent and reservation of rights. I hereby reserve all rights, titles, immunities, liberties, and entitlements under private trust law, natural equity, and original jurisdiction. I explicitly do not consent to the use, representation, or subrogation of my estate, person, or trust interests with any public, statutory, or corporate jurisdiction. Any previous implied or compelled joiner by legal fiction, nom de guerre, or presumed commercial standing is hereby rebutted and rejected. Take the time, your phone out and take a picture of this particular slide on page 33. Always remember, if you do not rebut, you have consented. Protection against merger, mischaracterization, and statutory absorption. The Declaration expressly guards against three dangers. 1. Merger of legal and equitable title. Destroys the trust under Perry on Trust, Section 267. The title to a trust estate must always remain distinct from the beneficial interest, and the two cannot merge without the destruction of the trust. Number 2, mischaracterization. Treating the heir as a debtor, a surety, or administrator of the descendant estate. Pomeroy's Equity Jurisprudence, Section 59. Equity regards the substance and not the form. It penetrates beyond legal fictions to reach the actual rights and relationships of the party. Rebuttal of fictional joiner. A. Nom de guerre, a legal fiction. The use of an all-cap name, John Henry Doe, or statutory person is a common legal fiction to draw individuals into commerce. Equity disregards such formality. Equity regards the substance and not the form. Pomeroy, section 59. By rebutting the fiction, you are insisting that you are not the descendant estate or corporate person presumed by statute. You remain the living heir and beneficiary. This is a powerful jurisdictional statement. It takes aim at the very foundation of consent in law. The principle that jurisdiction arises from either one, territorial power, or two, voluntary joiner and consent. What you are doing here is removing the second ground entirely by simultaneously reserving rights under the Constitution, trust law, and equity. Let's unpack this in treatises. I standing in the original jurisdiction of equity, original jurisdiction defined. Statutory jurisdiction arises from civil codes and commercial law. Equity's original jurisdiction predates statutory systems. It was established in the Court of Chancery in England and preserved in America to correct the rigidities of common law. Equity's maxim in action. He who does not repel a wrong when he can induces it. The maximum imposes a duty. A silence equals consents. By declaring your non-consent and reservation of rights, you fulfill the equitable obligation to repel presumptions. Otherwise, administrative and statutory jurisdictions presume you have acquiesced. Conclusion. This declaration asserts beneficial standing that you are the Cestui Que Vie equitable life tenant and living heir. Anchors in natural right and equity, succession and inheritance and enjoyment are secured as retained rights. It separates titles, legal title with trustee, beneficial enjoyment with you. Prevents destruction of trust merger, mischaracterization, and statutory absorption are barred. Establishes jurisdiction. Only equity applies. Statutory and commercial law are excluded. In effect, you create an ironclad record. Notice is given, jurisdiction is fixed, and the fiduciaries are bound in conscience. Source of title, divide inheritance, the bloodline, and private succession. Equity protects inheritance as retained natural right, independent of statutory recognition. The Ninth Amendment of the United States Constitution states the enumeration in the Constitution of certain rights shall not be construed to deny, disparage others retained by the people. Your right of the bloodline, descent, and succession is a retained right. It does not need to be granted by a statute. Wilkins versus Ellett, 76, U.S. 740, 1869. Property rights descend to heirs and beneficiaries, and creditors or administrators cannot divest them without due process of law. Specific conveyance. Your equitable life estate arises not from corporate citizenship or statutory franchise, such as the states, county, and cities, but from the natural succession, a right the Constitution already secures against impairment. Equitable support. Kent's Commentaries, Volume 4, page 305, 1826. The trust estate is considered in equity as the real ownership, and the trustee is but the instrument through which the Cestui Que Vie Trust receives the benefit. Reinstatement second of trust, section 2. A trust is a fiduciary relationship with respect to property arising from the manifestation of intention, whereby the legal title is held by one who is subject to equitable duties to manage it for the benefit of another. A specific conveyance. This means that you, as the living heir, hold the substance of ownership in equity, while the trustee only holds the bare legal shell. Conclusion. By declaring standing in the original jurisdiction of equity, you achieve several things. Constitutional protection. You reserve retained rights under the Ninth Amendment. You are secured within your private contracts under Article 1, Section 10, and invoke due process. Trust doctrine. You assert beneficial ownership while rejecting fictional joiner into a descendant's estate. In other words, when they force the all-cap name upon you, that is what they are doing, is creating the fictional joiner. Strategic American application. The Seste Cuvee doctrine ensures that no estate can be presumed, abandoned, or probated while the beneficiary lives. In the U.S. law, courts recognize that the burden of proof of death lies on the party asserting it. Johnson v. Fleet, New York. This makes your declaration as a living heir in Seste Cuvee more than symbolism. It is a due process safeguard against statutory presumption. Constructive trust principles. The reinstatement of trust makes clear a person may hold legal title without beneficial interest and vice versa. Reinstatement second of trust, section 17. This means that even if the fiction name, your name in all capital letters, is treated as holding legal title, equity preserves the beneficial interest in you unless you have abandoned or fail to assert it. In other words, when you fail to claim you are the living man, as well as the beneficial interest to the all-cap name, then the court systems, as well as the city, county, state regulators who are elected, will do everything they can to take everything from you without due process. Jurisdictional imperative, equity and conscience. Your declaration closes by demanding application only in equity, trust, and conscience. This is critical. Story, equity jurisprudence, section 64. Equity looks to intent rather than form. Equitable maxim. Equity regards the beneficiary as a true owner of the trust estate. Specific conveyance. By reserving jurisdiction in equity, you explicitly exclude statutory presumptions of personhood or probate, ensuring your intent governs and substance prevails. Summary. Kent's commentaries and stories of equity jurisprudence brought the Seste Cuvee doctrine into American law. U.S. courts from Johnson v. Fleet to Wilkins v. Elliott consistently upheld that the living beneficiary determines the duration and protection of the estate. The Constitution's Contracts Clause, due process, and full faith and credit provisions secure these equitable rights against statutory encroachment. Strategically, declaring yourself Seste Cuvee in the present defeats presumptions of death, abandonment, or statutory joiner. Pomeroy reminds us, equity penetrates beyond legal fictions to reach the actual rights and relationships of the parties. Equity jurisprudence, section 59. By invoking an original jurisdiction of equity, you are situating yourself in the forum of conscience and fairness, where the living heir is recognized as beneficiary and where rigid statutory presumptions cannot override natural rights. Remember, we have two forms of government. We have the republic form of government de jure, which is in the private standing, and we have democracy, the form of government known as de facto, where you have commercial standing. Again, when we look to the left side, you are free from all aspects of government intrusion, as long as there's not an injured party. We're on the right-hand side in democracy, commercial standing, you're presumed guilty, and you must prove that you are innocent. You are not a man or woman, a son or daughter created by God, but a fictitious entity created by government, violating your religious beliefs. Once again, the Ninth Amendment Party.com. We're on the land for the United States of America. In God we trust. Come and join our movement of restoring we the people's unalienable rights today. Thank you once again. Have a beautiful evening.